Will there be any approved zoning areas for an establishment in the South Phoenix area for dual medical and recreational?
So, good question. Dual, yes. Right now in the city of Phoenix, medical marijuana is allowed if you have an establishment as an accessory use, which means you're selling establishment and medical, you are permitted to do that. Right now, nowhere in Phoenix can you open up an establishment only license. We have to fix that problem.
There's a question about, can a municipality be more lenient than DHS on protected areas?
So, good question. And again, this is where the dual regulatory framework, one thing I will tell you, the Arizona Department of Health Services and cities have all established great relationships. So one, don't try to pull the wool over one of their eyes because they talk to each other. And I think that's a good thing, but no. So the cities have their own rules, right? So the big rule with Arizona Department of Health Services is you have to be 500 feet from a school for medical. If you look at the establishment license, they took that out. So there are no protected uses from the state perspective for establishment only, but you likely will still see protected uses for establishments with the cities, but the state can't waive the city requirements and the city can't waive the state requirements. Amy, does that make sense?
Yes, that's really helpful. There's a question here about, and it's framed as, is it better to look in industrial or commercial space? But maybe you can talk a little bit about the difference between industrial and commercial and how they might apply, even though we understand each municipality or jurisdiction may look at it differently.
Yeah, I mean, again, some cities only allow you, whether you're retail, cultivation, or infusion, to be in industrial. Think about industrial. Industrial is that stuff by the airport. Industrial is, it's industrial zone property. It has buildings, it has warehousing, it has all those things. Commercial property is your hard corner, right? It's where your grocery store is and your nail salons and those types of places. They have more foot traffic. I think in an ideal world, and this gets to be a business decision, you want your retail to have more foot traffic. But I'll tell you, some of the best dispensaries so far in the state are in strange little industrial corners, and people find them.
I would just like to add something to that, though. I think a lot of times people see industrial space and assume that it's not highly regulated and assume that there are no CSCNRs and nobody cares what you do there. Look out. Sometimes it's the most highly regulated space in your area. Reason being, when industrial parks are established, someone's subdividing space and they care what happens for the saleability of each subsequent piece. So don't let that fool you. Industrial space does not mean less regulated.
Even though it looks like garbage. And a lot of those places aren't permitted properly, and then you end up with permit issues with the cities.
Exactly. You inherit all of those headaches. So industrial is amazing, and you've got a good shot at getting industrial space for a number of reasons. But be careful. It could be highly regulated and have a ton of pitfalls that have been hidden.
Yeah, sometimes cheaper, too.
Sometimes cheaper. Well, not now.
Yeah.
Industrial's the darling, but sometimes cheaper.
So I noticed we actually have a couple questions about the sublease. So I think I'm going to rephrase those questions for the two of you. And maybe it's a where to seek this advice. It looks like there's two people who might be landlords who own buildings, and they're asking about leasing to multiple cultivators as a landlord at the same location. And so without giving legal advice from the stage, maybe you can send people somewhere or you can give some sort of more broad answer.
Want me to take?
So, yeah, I would just also say, when I said subleasing is a possibility, a lot of times I'm not talking about multiple sublessees. I'm really talking about, from the dispensary perspective, if a dispensary fails or moves, sometimes they'll have a long-term lease that they can't get out of, and they need someone else to come in and take the space. So it's a second-generation issue in terms of making your business present. You sometimes get some goodwill inherited. So I'm talking. There are two different ways to think about this. One is subleasing at the very most fundamental level, which is there was a dispensary here, now there's not. I want to be there. I'm going to take over. But I will let Lindsay touch on multiple subtenants because that is a regulatory issue.
Yeah, I mean, Amy, the answer is that's an Arizona Department of Health Services question, because again, when you get into this dual regulated framework, you need the right zoning.
Yep.
You need a building permit, which is a certificate of occupancy, and then you need your authorization to operate. And that's what the Arizona Department of Health Services gives you. Are we aware of buildings that have multiple operators in them with multiple authorization to operate? Yes, but you take on a lot of risk, because you have to, not only from a nuisance standpoint of odor, noise, dust, those situations, and potentially everyone losing their entitlement, their use permit to be there, but you also have to behave properly with the Arizona Department of Health Services. And then from a nuance perspective, they need different suite numbers. So you need a different certificate of occupancy and a different suite number, but please check with the Arizona Department of Health Services before you venture into that.